To begin with, business and immigration law updates, which will be hosted by attorney Ramesh Khurana of the Khurana Law Firm. To accompany him is attorney-at-law Kenneth Haber. Let's join these two gentlemen in their discussion to find out what's new.
Good morning. My name's Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General. And this is the Capitol Forum. With us today is Ramesh Khurana, a very well-known immigration attorney who has represented people across the country from across the world. And he's here to talk to us today about some immigration issues, including the I-9 form. Ramesh, welcome.
Thank you very much, Ken. I appreciate your generous introduction for me this morning. And I really feel that you have made me realize that if I am doing something great.
You are. You're helping people in their problems, in their legal problems. People do not really realize how much they need their attorney until they need their attorney. And then they appreciate the attorney. And the attorney really is compensated not just by money, of course, but by the satisfaction of helping people. And people don't realize that we really depend upon that to go through all the difficulties the people have and the emotional burdens that they have that we carry with them. And you do a great thing when you're helping your clients.
No, I do agree with you, Ken, when I look at your practice. And it is commendable the way you help the physicians who unfortunately get into trouble.
And they don't have to do anything wrong to get there either.
That's right.
Let's start with the I-9 form from the immigration agency, ICE. Can you explain what that is?
Yeah, sure, Ken. The form I-9 is a very important document which every employer should know if he or she doesn't know about it. Now, it's a mandatory requirement for all businesses to complete the form I-9 on the first day of the business when the new employee is on board. When I say that on the first business day it has to be completed, because there are three parts of form I-9. And part 1 is to be completed by the new employee. So the purpose of this form is to verify the identification and the work authorization. Because if you don't verify the work authorization and identification of the person, maybe you are helping a wrong person. You are helping a person who is unlawfully present in the United States, and you may be getting into trouble.
You can actually be helping a terrorist have cover if you don't check his authorization. We all have to be, in this day and age, we have to be basically policemen in order to ensure our nation's security.
You know, you are a defense attorney, so I'm glad that you brought into discussion this aspect as well. You never know. So proper identification is very important. And this is the form I-9, which is going to help you.
And they have to show their passport, driver's license. What sort of things do they have to show to complete this form?
This form provides basically a list of documents which are acceptable for the purpose of verifying the identification and the work authorization. There is a list A, B, and C. So list A would include basically the passport and all those kinds of things, and then we can look at the green card of the person or work authorization, any kind of work authorization. And this work authorization is issued by the Department of Homeland Security's agency, USCIS. And once you have verified the work authorization and the ID of the person, you hand over the form I-9 to the employee on the first day of the joining. So that's why law says that on the first business day, this form, part 1 of the form has got to be completed by the employee. So basically it would ask name, address, social security number, and the type of document which they want to give. We have to be careful in not asking more than what is required to complete it. And other thing I always tell the employer, while you are recruiting people, interviewing people, you don't have to ask for this documentation. Once you are decided that you want to hire a person, then of course you want to make sure that person is legally authorized to work in the United States.
That's very important. The employer has to fill out part of that form also, doesn't he?
Yes, employee has to complete part 1 of Form 9, and once he has completed the part 1 of Form I-9, he or she will hand it over to the employer, then employer will complete the part 2.
What does the employer have to verify or write up concerning the part 2?
You know, employer is going to look at the work authorization document, whether it's a passport, green card, any kind of employment authorization document, and the employer is going to state on the Form I-9, like what document makes that employee eligible to work in the office. So if there is any expiry date of the work authorization, because work authorizations most of the times are issued by the USCIS for a period of 2 years. So you have to state the expiry date. Then the most important thing is there is a certification by the employer. Employer is signing under penalty of perjury that this statement is correct. And likewise, employee, while he is completing part 1 of Form I-9, he or she is also certifying under penalty of perjury that this is the valid document which is being produced.
How long does the employer have to retain this document, and what's the consequences if they don't?
Ken, it's a very good question. For how much time the Form I-9 has got to be retained? It has to be retained for a period of 3 years from the date of completion of this document. And if the employee services have been terminated, then 1 year after the termination of the job. And you have to keep the file ready for inspection by the ICE. ICE is another agency of the Department of Homeland Security. They may come and knock at your door and they say, we are here for the inspection of I-9s. It's very surprising, very surprising. And sometimes I have seen people are caught unaware. They are not even aware about the completion of Form I-9, which is of utmost importance to all businesses because there are severe penalties. So I think this is the message to the audience. Please talk to your attorney or lawyer of your choice, and you should know what is Form I-9, when it is required to be completed, what are the types of documents which are acceptable for the completion of Form I-9, and what is your role as an employer.
Does a person have to complete the I-9 if the employee is a citizen and he knows they're a citizen because, you know, they look like me and they speak like me and, oh, he's safe? Do they still have to fill out that form?
Yes, because as I said, each and every employee has to complete this form because this is the employment eligibility form. Even though a person looks like he or she is born in the United States, but without ID and documentation, you really don't know about it, you know. So then you need the certification signed by him under penalty of perjury. So that makes that person bound by the certification. And if that person is signing a wrong certification, I'm pretty sure ICE can sue him or ICE can put that person in trouble because of the certification under penalty of perjury. There may be a criminal prosecution as well.
What's an H-1B employee?
Say again?
The H-1B employee, what are they?
Oh, okay. Now, H-1B employee, basically they have got the work authorization document in terms of H-1B approval. So their H-1B is approved. So this is a special kind of petition which is to be filed by the employer. And when we are saying H-1B employee, now most of the times these kinds of employees are working for the employer who are completing Form I-9s. They know the whole scenario, like because they are the ones who are sponsoring that particular employee. So based on the H-1B employee, they know their status, that this is a non-immigrant status. So usually the H-1B petition is approved for a period of 3 years and it can go maximum for a period of 6 years. So you have to make sure that the form says the expiry date, and when it gets extended. Now, there is another part attached to that form. When then you have to look at the expiry date, and when the expiry date gets extended by filing a new petition, then you are stating the new expiry date on the form.
I see, but it's a maximum of 6 years.
Maximum of 6 years, which can be extended under certain circumstances, which is a topic for other day, but it does get extended. Usually I have seen in my practice people who come here on H-1B and they are settled here, their families are settled here, they don't want to go back to their home countries, and they have the provision of starting the green card process, and they can start the green card process once they are on H-1B, but because of the long waits, because priority dates are not current, and they have to wait for pretty long time, because I have seen in my practice, if Indian nationals, they are sponsored on EB3, wait time is close to 11 years. 12 years. So, but there is a provision once the green card process gets started. So, under certain circumstances, their H-1B will be extended beyond 6 years.
Well, that's good to know. Does the DOL get involved in these immigrant cases in any way?
Yes, DOL does get involved, especially as you touched the topic of H-1B employees. All these H-1B employees petitions are filed based on the certified labor condition applications, and these labor conditions applications are filed by the employer or employer's agent, who may be an attorney, with the Department of Labor, and who does the certification of labor certification application. And if there are any violation of the labor condition application, which Department of Labor can find out based on random selection of employers or based on specific complaints filed by the H-1B employees. Yes.
Does the H-1B employee have some sort of statute of limitations in order to file an appeal with the Department of Labor?
You know, in fact, once you know that certain irregularities or violations have taken place, you should file the complaint within 1 year, but there is no statute of limitation as such.
I see, I see. Is there a 30-60 day rule to start the payroll of a H-1B employee?
Yes, there is a 30-day, 60-day rule. If an employee is coming from overseas, then the employer should start paying him within 30 days if the employee is willing and available to work, and if the person is sitting here for whom change of status is approved within 60 days.
I'd like to thank you very much for coming to the Capitol Forum and explaining these complicated rules. Do you have any advice for the viewing audience concerning this?
Yeah, first of all, I would like to thank you, Ken, for inviting me to this studio. I have enjoyed your questions, which I always do. And my advice to the audience is, I-9 process is a very complicated one. You really need to know how to complete the form I-9, because violation results in serious consequences, both civil and criminal. So please talk to your lawyer. Thank you very much for being with us, and thank you.
Thank you.